I have published a new post earlier this morning, May 30th, discussing stock, bond, and treasury bill trades made over the past week. I purchased 8,000 in principal amount of first mortgage bonds issued by operating utilities and 2,000 in a senior unsecured bond issued by a utility holding company. My T-bill purchases total 15,000 in principal amount. My stock trading is near a virtual standstill with a net purchase of slightly more than $400. The reasons for this stall mode for stock trades includes less appealing valuations after the recent stock market rally and a restraint on stock selling into the rally due to the extremely low stock allocation that I now have. I'm trying to put the brakes as much as I possibly can psychologically on lowering my stock allocation further. The tariff war started by Trump is not over after a three-judge panel ruled that he exceeded his authority to impose reciprocal tariffs under the International Emergency Economic Powers Act of 1977. There are several reasons why the chaos will continue. Trump has other statutory options available to him to impose tariffs, and the injunction issued by the three-judge panel may be stayed by the U.S. Court of Appeals for the Federal Circuit. If the injunction is stayed, the tariffs issued so far by Trump under that law and possibly others that he would implement during the stay period will remain in effect pending resolution of the appeal. The appellate court has issued a temporary administrative stay of the three-judge panel injunction to give the parties more time to file briefs on whether the standards for issuing a stay are present. The plaintiffs have until June 5th to file a reply to the government motion to stay, and any reply by the government has to be filed by June 9th. Those standards for granting or denying a motion to stay include weighing whether the government has shown a strong likelihood of success on the merits, potential irreparable harm to the government if a stay is not granted, minimal harm to those paying the tariffs if the stay is granted, and a public interest that favors or does not favor granting the stay. I would rule that the stay is not justified using those standards. A decision by the appellate court may occur as early as June, and it doesn't matter what I think on this issue. What matters is what they do. If the stay motion is denied, Trump will then impose, in my opinion, up to 15% tariffs under a different statute to address balance of payment issues in foreign trade, but those can only remain in effect for 150 days. During that period of 150 days, the administrative groundwork for issuing tariffs under other statutes will be laid, and that will be predetermined by Trump before the investigation by the administrative agencies in charge of that, laying that groundwork occurs. There may also be soon product-specific tariffs imposed under another statute that Trump has used to levy the 25% tariffs on all aluminum and steel exports to the United States. So everything is still in a chaotic state with uncertain and unknowable eventual outcomes. I noted in a prior video that the reasoning of the three-judge panel will resonate with the 6 Republican justices who have used the same reasoning in other decisions. The underpinning of those prior decisions involved their approach to the separation of powers doctrine. The legal problems for the government include the non-delegation doctrine for power reserved to Congress and the major question doctrine that is favored most definitely by the Republican justices. Would it be constitutional for the Republican Congress to delegate to Trump the constitutional power reserved to Congress in the Constitution to tax and spend? The answer is no. And it is Congress, not the president, that has the power to levy tariffs. So there is at best a narrow exception to non-delegation of a congressional power to the president, and that would be limited to when there is an emergency involving national security and the economy. And that is when the major question doctrine comes into play as well, which the Republicans have used in the past to overrule the Chevron decision and Biden's student loan forgiveness plan. For the executive branch to exercise powers reserved to Congress in the Constitution, the delegation must be clearly stated in the act when the issue involves a question of significant economic or political significance, which is clearly the case with Trump's reciprocal tariffs. There is no mention of tariffs by name in the 1977 act used by Trump as the legal basis for the reciprocal tariffs. The authority for him to do that has to be inferred from the language, and that is not sufficient, assuming the Republican justices follow their past decisions on these legal issues. I view them as result-oriented, meaning that they will find a way to achieve the desired result, even if that requires the abandonment of a judicial standard viewed as sacrosanct by them. I have a video on that subject, which I will link in the more section below. I would note that Trump accused China of violating the recent agreement that was reached on the tariff issue, and the Treasury Secretary says that the negotiations have already stalled, and that did not take long, which is just another indication that we are far from reaching a resolution of Trump's tariff war.